Okay, so we've covered these various intentional torts. Again, now we've covered these two ends of the spectrum, right? We've covered cases of negligence and cases of intentional torts. And I mentioned at the top of this lecture that there is this middle ground or this gray area called reckless misconduct, where it doesn't quite meet the standard of negligence and it doesn't quite meet the standard of intentional torts. So what we have with reckless misconduct is an intent to act, but no intent to actually cause harm. Okay, so you can see there by looking at our three areas of tort law here how this falls in the middle, right? With negligence, we had no intent to act and no intent to harm. With intentional torts, we had intent to act and intent to harm. And then again, reckless misconduct is falling here in the middle. So a little bit more here on reckless misconduct, and I will say that this is still a fairly new legal concept. You can see there down at the bottom of the slide that it first came about in a lawsuit actually here in the state of Illinois. This a Nabozny versus Barnhill case, which I'll talk about here in a minute, really created this reckless misconduct standard through a court precedent. So it's still a fairly new legal concept, which sort of means that, we're kind of figuring it out as we go in court. So it's not quite as established as, say, negligence that has its four elements. But a little bit more here on reckless misconduct. So basically you have someone who's intentionally acted but hasn't thought about the potential harm that their actions could cause. Hence the term reckless, right? Someone has acted in a way that is potentially harmful to others, haven't done it, purposely to inflict harm like you would in an assault or battery case, okay? The big key here in Reckless Misconduct Act is the actual state of mind that accompanies the act, which is, if you can imagine, is tough to nail down, right? It's hard to know what someone was actually thinking when they committed a reckless act. And certainly the only information we have is from that person, right? And what they can tell us about their state of mind. So I'll tell you a little bit more about this Nabozny case. So this case occurred in a high school boys soccer match. Basically, you had these two players. One was the goalie and one was a forward for the other team. The goalie ended up down on the ground to grab the ball. The forward for the other team went to go kick the ball, but the goalie's head was there instead. So basically, this player kicked the goalie's head. The goalie suffered some pretty severe head injuries because of the kick. So when this case initially went to trial, the trial court favored the defendant player, right? Basically, the court was applying the intentional tort standard, and ultimately the judge said, we don't think this is an intentional act. Like, we don't think that this kid intended to harm this goalie. He was simply going for the ball. So the case goes to the appellate level from there, and the appeals court says, you know what? We get it. This isn't exactly an intentional tort, right? There's no intent to harm, but it's also not really fitting our definition of negligence, right? So there certainly was more than just a careless action here. This person intended to act, intend to kick the ball. They just didn't intend to harm. So this is where the reckless misconduct standard is basically created through this court decision, where the judge says basically we have something that's not quite either, and we're going to create this new standard called reckless misconduct. So the individual intended to act, they just didn't intend to harm. They acted in a reckless manner. Okay, so like I said, reckless misconduct is still a fairly new legal concept. So we don't necessarily have that bulletproof list of elements like we do in a negligence claim, like we do with assault and battery. So basically what a court does in a reckless misconduct case is sort of weigh these general concepts. They ask some questions about what occurred, and then they weigh those answers in order to determine whether or not reckless misconduct occurred. So they might consider, what's the context of the actual activity? What are the rules? Was what occurred actually within the conduct of those rules? So thinking about the context of the actual activity that occurred. They might ask more about the setting, about when did it actually occur. So did this happen during organized play where a high level of intensity was expected, or was this practice where that same level wasn't expected? So the context in terms of the setting matters. And then what is the age of the participants? Are we talking early high school, early college? Are we talking, 4 to 5-year-olds? It makes a big difference, right? In terms of mental capacity, young kids aren't necessarily going to be aware of the potential harm of their actions, right? Where we would expect maybe older high school or college kids to have a little bit higher of awareness of the potential harm or risks associated with their actions. So age of the participant is going to be taken into consideration. And then finally, the court's really going to be interested in the intent of the defendant. This goes back to that slide a few slides ago. What was their intent when they acted? And again, this is tough to really nail down because really we only have one source here, right? The defendant. And probably they're going to be guided by their lawyer to say, they certainly didn't intend to harm anyone. So that could be a little bit tricky to nail down, but that's why there are these, variety of questions or factors that the court's going to take into account. Okay. So, what potential defenses might be available to someone who is sued for reckless misconduct? Well, the first step might be to just argue that it wasn't actually reckless misconduct, right? To maybe argue down, say it was actually negligence and not reckless misconduct. Again, negligence is on the lesser severe end of the spectrum, so you would expect damages to be smaller. So you might just argue, hey, there certainly wasn't any intent to act here. It was just a careless action. Can we look at it as negligence and not reckless misconduct? So that would be one approach. You could certainly argue assumption of risk, or that concept of consent that we looked at with assault and battery, right? Saying that basically this is part of or an inherent risk associated with this activity or sport, and therefore there's really no path for a lawsuit. One last defense that might be considered would be waiver, right? Or potentially an agreement to participate that we talked about last week. So being able to pull that waiver and say, hey, you said that you would give up your legal right to sue in these cases. Again, in order for that to be successful, the waiver would need to be very detailed and include statements regarding reckless misconduct, not just negligence. And just to wrap up here real quick in terms of reckless misconduct, this one is tough for courts to apply because on one hand, they want to encourage vigorous competition, right? That's what sport and recreation is about to some extent. So on one hand, they're trying to allow for that to take place so that people don't actually have to fear that they're going to be sued just by, participating or competing in something. But on the other end of that, they also have to be concerned for the safety of participants, right? So it's sort of a balancing act here for courts when they look at reckless misconduct cases. Certainly they want to weigh, keeping activities vigorous in terms of competition, but also they want to consider the safety of those individual participants. So it's certainly something that they have to weigh over time. Okay, so I will just summarize here real quickly and then let you move on for the day. So, we've spent the last 3 weeks now talking about this concept of tort law. Again, we said that there are a variety of tort lawsuits that could be filed against K&R practitioners or organizations. Again, it's really important that you are able to identify these 3 areas of tort law, that you're able to apply the various elements for each type of lawsuit that we've looked at, and also that you're able to identify key defenses for each of these types of laws. So again, we want to be able to look at these from the perspective of the plaintiff and how they might go about proving that one of these lawsuits move forward in court, but also we want to think about it from the perspective of the defendant, right? How might we as K&R practitioners, if we are to be sued in a case like this, how do we move about defending those actions in court? So hopefully these past few weeks have given you, a broad overview of the concept of tort law.